Please stand by. Good day and welcome to the Labor Laws and Executive Compensation Hot Topics web conference. Today's conference is being recorded. At this time, I turn the conference call over to your host, to Jeff Atkin. Please go ahead, sir.
Thank you. So first of all, welcome to the second session of our Energy Boot Camp series. And my name is Jeff Atkin. I am the chair of our solar energy team, and primarily focus on kind of corporate counsel and advice to energy companies. This particular, as way of a little background and context, this boot camp series is currently a 6-session series that's designed primarily for energy companies, but really the topics are applicable to all different industries. Today's topic, we'll go over in a little more detail. Labor laws and executive compensation is an example of that. Last month, in the first session, we covered Foreign Corrupt Practices Act and anti-compliance, corruption compliance, and that was also one that was fairly broadly applicable. In a few of the future sessions coming up, we'll cover joint ventures, buying distressed assets, and financing structures. So this webinar, as mentioned, is being recorded. We will have it posted to our website, and there is a specific website that's available for all of the boot camp sessions. So if you missed the Foreign Corrupt Practices Act session, for example, and would like to view that, the video is available and the materials are available on that website. After the session today, we will send out links to all the participants so they can access that information as well. So first, before we get to the actual session, wanted to cover a little bit of housekeeping. Today's program is 1 hour, and we will be applying for one general CLE credit. For Kansas, New York, and New Jersey attendees or licensees applying for credit, you must fill out the attorney affirmation form. And if you look on your website, sort of on the right-hand side, below housekeeping items, there's an items for materials. And in that materials link down below, there are 2 items. One is the final slides, the copy of today's slides, and the second one is the attorney affirmation form. So you'll need to fill that out and including write down the course code. For New York attendees, we'll have a special code that we provide at the end of the session right before the Q&A portion. So that's the housekeeping. As mentioned, we'll have a Q&A session at the end. It'll be probably 5 minutes or so, and you can submit questions on the website right here on the bottom right side. There's a little section where if you have any questions as we're going through, you can type those in, and then we will field some of those at the end. If we don't get to all of them, we can email back some answers at that point. So with that, I'd like to jump into an introduction to this session, Labor Laws and Executive Compensation. Our 2 speakers today, Josh Agan, who is a senior counsel in our Milwaukee office. Josh specializes in advising private and public companies on executive compensation, employee benefits, and related items. Josh will cover our hot topics in 2013 for executive compensation. After that, Jeremy Wooden, who is an attorney in our San Diego office. Jeremy handles a variety of labor matters and has been very successful in California in defending a number of clients in wage and hour claims and other labor matters. So with that, here's the agenda. Again, number 1, we'll just run through the executive compensation trends and issues, and Josh will take care of that. And we'll go through a little more detail on labor and employment refresher from Jeremy Wooden, and then we'll handle some Q&A at the end. So thank you. With that, Josh.
Thanks, Jeff. So today I'd like to just give a quick high-level overview of some current trends that we're seeing and legal compliance challenges in the area of executive compensation. The first topic I wanted to address is just to take a couple minutes to highlight some fairly dramatic shifts in types of pay that are being provided to executives in recent years. The first is a real strong trend toward performance contingent long-term incentive compensation. These are equity awards typically that vest only to the extent certain performance goals are achieved. They've been replacing what used to be the most common types of equity awards like time vesting restricted stock or just stock options that only vest based on continued service. So to date, nearly 40% of Fortune 1000 companies are now using performance shares, which are full value awards that are earned only if performance goals are achieved. And performance shares even outnumber stock options among the top 250 companies. The second really significant trend that I've been seeing is, I guess, a continuation from the last few years toward reducing or eliminating perquisites and reducing or eliminating tax gross-ups. These are being eliminated or reduced due to pressures from shareholders and negative media scrutiny of things like personal plane use by executives. The tax gross-ups are just seen as expensive, and they certainly can get exorbitant when they apply. And in some cases, when these are being eliminated, the executives will receive regular cash compensation to compensate them for it, but not always. Sometimes they're just being taken away. Shifting gears a bit, the first legal compliance issue that I'd like to highlight involves everyone's favorite subject, taxes. But specifically, I'd like to just talk about some of the bad tax consequences that can result from not complying with the rules that apply to deferred compensation. The code section here is 409A. It was adopted in 2005, but it's just now rising to prominence as a serious and potentially costly compliance issue because, as I'll talk about a little later, the IRS has begun seriously auditing deferred compensation compliance, and I think there's an expectation that people have had time to adjust to and implement the rules. So 409A applies to all deferred compensation, which is defined as a legally binding right in 1 year to compensation that is or may be payable in a later year. So 409A is broader than you might think based on that definition. It covers arrangements including severance arrangements, so even employment agreements could be implicated, supplemental retirement plans, and some equity arrangements like discounted stock options and restricted stock units. And note this is restricted stock units, which are the contractual right to receive a share rather than just regular restricted stock where you have an actual share that's issued immediately but is subject to forfeiture if the service requirements aren't met. The basic idea of 409A is it tries to limit control by service providers or employees and the employers over when income can be recognized, taxed, and deducted. So the limits under 409A take the form of very strict rules on when employees can elect to defer compensation and when the compensation that is deferred can be distributed. There are just specified events that on which you can have a distribution. There are things like a fixed date elected in advance, separation from service, death, disability, a change of control, or unforeseeable hardship. Other than that, you can't distribute deferred compensation. So the penalties for noncompliance with 409A are severe. They include immediate recognition of the compensation that you were trying to defer. There's an extra tax of 20% on the compensation, and there are interest penalties. In addition, some states tack on additional penalties for 409A violations. In California is a good example where they essentially doubled that extra 20% tax so that you end up with a 40% extra tax. As I mentioned, the one reason I expect this to become an increasingly prominent compliance issue is that the IRS has begun seriously auditing companies for compliance with 409A. And as I highlighted, 409A if violations incur steep penalties, and it's a pretty complicated regime to comply with. So it's easy to mess up without meaning to, and there's no sort of materiality exceptions for compliance except for a few de minimis thresholds that are specified in the regs. So the audits have begun with these information document requests that relate specifically to deferred compensation arrangements. So if you get one of those, be careful in responding to, and you may want to consult with counsel to make sure that you're putting yourself in the best light possible. There are 2 voluntary correction programs available for noncompliance with 409A, but they're limited in their scope. They're not available if the employee is under audit at the time. You also cannot correct operational errors under 409A more than 2 years after they occur. The bottom line here is just that there's a very, very strong incentive to catch and fix your 409A problems before the IRS does on audit. The IRS will go to court over technical compliance issues. This has been illustrated recently by this case Sutarda versus U.S. in the U.S. Court of Federal Claims. This is a case involving discounted stock options under 409A. As I mentioned, they are subject to 409A, and the IRS has prevailed so far. The basic 409A rule on when you're granting stock options is you want to try to be exempt from 409A, but you can only be exempt if you grant your options so that the exercise price is no lower than the fair market value of the underlying shares on the date of grant. So essentially don't grant discounted stock options or you'll have to comply with 409A. In Sutarda, the IRS alleged that he was the CEO of Marvel Technology Group, and the IRS alleged that his options were granted at a discount and that they also did not comply with 409A, and therefore there was a deficiency of more than $5 million. The company actually spotted the discounting issue back in 2006 and tried to fix it by having the CEO repay the company for the difference between the discount and what the fair market value of the shares were on the grant date, but the IRS essentially said no dice. So recommendations here, document very clearly the basis for your determination of the fair market value of shares underlying options when you grant those options. Also document the timing of the option grant approval so that there's no question as to what the relevant date is for determining that fair market value. And then also document the timing of notification to award recipients. These are all items that the IRS has asked about in its audits. Another recommendation would be to consider auditing the compliance of your deferred compensation arrangements to make sure that you're meeting all of the 409A requirements. 409A requires that your documents on their face comply, as well as that you comply in operation. So it's a good idea to keep tabs on both of those things, especially if you have a plan that you think, like a severance agreement that you think may not have been looked at for years, particularly since 2009, which is when the final regs came into effect. It's a good idea just to revisit that to make sure you don't have a 409A issue because, as I mentioned, it's better to find it before the IRS does, and then there's some possibility of correcting it without incurring the severe penalties. Next, I'd like to spend just a couple of minutes on some key legislative and regulatory developments in executive compensation. As many of you may remember, Dodd-Frank became law in 2010. It included a number of executive compensation rules. They generally apply only to publicly traded companies, but they've really, I think, also affected the perceptions of what are best practices for non-publicly traded companies as well. Dodd-Frank introduced Say on Pay, Say When on Pay, and Say on Golden Parachutes. These are all advisory shareholder votes on the compensation of a company's top executives. So 2013 is the third year where companies have been required to have the Say on Pay vote. The results to date suggest that this vote is becoming increasingly routine. Less than 2% of companies have had failed votes in 2013 so far. And the proxy advisory services like ISS that make recommendations to institutional shareholders on how to vote on things like Say on Pay, their influence may be diminishing somewhat as time goes on. There seems to be a lower correlation between their recommendations and the voting outcomes. which is in general good news for companies. Aside from say-on pay, another significant Dodd-Frank change relates to compensation committees. Dodd-Frank requires heightened independence standards for directors who serve on compensation committees. They essentially have to meet the audit committee standards, which means they can't have any relationships with the company or management other than as a director. Another requirement from Dodd-Frank that applies to compensation committees is that committees are now required to evaluate the independence of their advisors before they engage them. Independence meaning independence from management. And so this applies to compensation consultants and also attorneys that provide advice to the compensation committee. So a deadline here, if your company is publicly traded, that's coming up July 1st, 2013 is the deadline for having your compensation committee charter amended to incorporate the requirement to conduct an independence evaluation. There are more regulations to come under Dodd-Frank when the SEC manages to catch up in its rulemaking. These were expected a long time ago, but the SEC has had its hands full. One of them is there are going to be required disclosures about pay for performance, essentially showing the relationship between the pay of the top executives and the performance of the company. Pay ratio disclosures showing the ratio of the median employee compensation at a company to the compensation of the CEO. Anti-hedging disclosure rules are expected. This will require disclosure of the company's policies as to whether executives and directors can hedge their investments in company stock. And perhaps the most significant change still coming relates to compensation clawbacks. So this is a requirement for companies listed on stock exchanges. They'll be required to claw back incentive compensation, which includes stock options. In the event that there's a financial restatement, they'll have to claw back the compensation from executive officers. It's interesting. I've seen that idea start to filter through somewhat in the private company context as well. But the recommendation here is until the requirement actually comes out, I think the rules are actually promulgated. All we can do is just make sure that compensation that you're awarding now, that you have a contractual right to claw it back if and when you're required to under these stock exchange requirements if you're listed on an exchange. Finally, I'd like to just touch on some executive compensation-related shareholder litigation developments. In 2012 and 2013, we saw dozens of lawsuits filed against companies who failed their say-on pay votes. The allegations would include things like breach of fiduciary duty by the directors, a waste of corporate assets because they were paying executives more than shareholders wanted them to, unjust enrichment, and false or misleading disclosures in the proxy statements about compensation. In 2012, there was a new strategy used by plaintiffs' attorneys in these kinds of strike suits. They would file suit shortly before the annual meeting and try to get an injunction against the annual meeting as a tactic to extract a settlement with that added time pressure. Another element to these pay-related shareholder litigation suits is allegations that the company has bungled its Section 162M compliance. This is another tax code provision. Just to give you a 30-second overview, basically what Section 162M does is it limits the deduction of publicly traded companies that they may take for compensation paid to their named executive officers other than the CFO to $1 million per year. But performance-based compensation is exempt from that $1 million limit. But there are various technical requirements that you have to meet to qualify compensation as performance-based. For example, you have to have shareholders approve your performance goals every 5 years. You have to have the compensation committee set the performance goals for the relevant year 90 days into the performance period. So these shareholder suits will also allege that the company hasn't complied or hasn't met all these technical requirements of Section 162M, and typically allege at the same time the company is saying in its proxy statement that it believes all of its compensation is deductible under 162M. So that's another kind of new element in these strike suits. Most of the cases have been dismissed at the pleading stage, but there have been some settlements, and some of those have been sizable. So I guess the recommendations here are, if you are a publicly traded company, draft your proxy statement disclosures with the possibility of litigation in mind, especially when it comes to things like saying you think all of your compensation is deductible under 162M. Just revisit those requirements and make sure that you're meeting all of them in terms of procedure. And then I guess that, the other part was auditing your 162M compliance, just to make sure that's not an issue for you. So with those hot topics, I'll hand it off to Jeremy.
Thanks, Josh. The purpose of my presentation is essentially just to give a kind of an overview of some employment law basics, some issues we've been seeing, and some best practices. I think from a business point of view, employment laws, I think, are correctly seen as an increased cost of labor. I mean, the most obvious example being overtime, minimum wage, and then less obvious, sometimes less appreciated, is the risk of litigation, which we see bite a lot of smaller, younger companies, mid-sized companies who grew at a fairly rapid pace and never quite got around to implementing some human resources best practices or getting a really good employment manual and employment agreements in place. Some of the issues, just a quick overview of the issues I'll touch on. Some common scenarios I see and see with increasing frequency: more employees, more problems, at-will issues, trade secrets, employee inventions, the ownership of employee inventions, non-competition, non-solicitation clauses, non-disparagement clauses, wage and hour laws, leave laws, and then just a few things that are fairly unique or idiosyncratic to California. One common scenario I see increasing and expect to see more of as baby boomers leave the workforce is you get an hourly employee who's terminated for poor performance or a bad attitude, what have you. And then he or she files a lawsuit saying that her younger supervisor, who fired her and probably had written her up for a number of incidents or just basic poor performance, and the lawsuit alleges that she was terminated based on her age and the so-called evidence of this age discrimination, which usually in these cases it just seems absurd on its face. I met no one who I actually think is ageist or maybe I'm just biased towards my clients, but anyone who actually harbors a discriminatory intent towards people over the age of 40. But in these cases, you get as so-called evidence of ageist intent, these vague allegations that the supervisor treated younger employees better, or maybe there was some offhand comment made about dinosaurs or older employees. There was a published Google case that gives a good example of how these cases sort of get legs with these types of stray comments, where a gentleman in his late 50s worked for Google for a few years, and he was eventually laid off, and he filed an age discrimination suit. And his alleged evidence of anti-age discrimination was that his coworkers had called him slow, fuzzy, sluggish, and lethargic, and someone else called him an old fuddy-duddy, he alleges. And someone walked into his office once and said that his compact disc jewel case placard should be an LP instead of a CD. These comments like this, they're not dispositive. They don't necessarily mean the employer is going to lose, but they do tend to give cases legs, and hopefully the claims are ultimately found to be without merit at the summary judgment stage. Another common scenario we see is where a disgruntled salaried employee manager or someone in administration quits, and then later they find an attorney who seeks to turn it into a misclassification lawsuit, basically saying that this person and anyone else like them who was so classified as exempt from overtime laws and paid a salary, they were in fact misclassified, and the plaintiff in that case would seek back pay for all the unpaid overtime they worked, which can be quite significant for these types of folks. These cases are problematic, and it's a pretty common complaint amongst the defense bar, including myself, that these exemptions, a managerial exemption or the administrative exemption, there's an outside sales exemption to the overtime requirements, they're outdated. They were drafted, I guess 40 or 50 years ago in the Fair Labor Standards Act, and the labor force has changed, and these laws were drafted back when sort of the prototypical manager sort of underling scenario was, a manager of a plant who could be properly exempt from overtime, and those working on the production line beneath him or her. And just a lot of the language and the concepts in the law are outdated, but have not been updated, which can make them difficult to defend against sometimes. The concept of more employees, more problems is just simply as the size of your workforce grows, so too does your coverage under the various laws. So at the basic level, if you have one employee, they're going to be covered by wage laws, overtime, minimum wage. The anti-discrimination harassment laws kick in California, 5 employees. At the federal level, at 15 and 20 employees. And then probably the most sensible restriction I've seen and actually implemented recently to get a case, get a bunch of claims dismissed is in the Family Leave Acts, both California and federal. The employer is not required to grant that leave, up to 12 weeks of leave for your own or a family member's medical condition, unless the employer is large enough that there are 50 employees within 75 miles of your work site. That's just a situation where the legislature rather sensibly recognized when the law was implemented in the late 90s that these leave laws would really, overburden a small employer who didn't have other employees nearby to take the place of the person going out on leave. At will is, basic concept of employment law. It's still a key protection that employers have. This notion that you can, fire someone really for any reason other than the unlawful reasons of race or age discrimination. But it can be the at-will, kind of the default of at-will can be eroded by oral assurances to the contrary. The classic situation there would be, say, I'm an employee, I signed an at-will agreement at the beginning of my employment, but over the course of 5-6 years, I've gotten good performance reviews, and I've become pals with my manager, and he's told me that as long as I keep doing well, I'll always have a job here. That can turn into a breach of an implied contract claim, despite the at-will status, at least at the beginning of employment. And one of the best practices you can implement to prevent that is that the handbook should be very clear, and even the offer letter too, if there is one, about the at-will status, and that it can only be changed, the at-will status that is, in writing and by a, say a president or a high-ranking officer. You don't want to go too far, though, per the NLRB's recent ruling, and say anything to the effect of the at-will status can never be changed, or the employee agrees that they'll never seek to change the at-will status. the NLRB has held that that's an unlawful practice because it unlawfully restricts the employee from their basic rights to at least attempt to change their the terms and conditions of their employment. So the key there is just limiting the conditions under which it can be changed, and in writing and only by say the president or a high-ranking officer of the company. Trade secrets. Just a reminder, the basic sort of definition of trade secret is information, including a formula, pattern, compilation, program, device, method, technique, or process, and that meets two basic elements: that it derives independent economic value, and that it's the subject of efforts to keep its secrecy. I think on the second one, that maintain its secrecy. Non-disclosure agreements are strongly advisable. Making employees, sign non-disclosure agreements to protect from disclosing trade secrets. It's just sort of a no-brainer if an employer files a trade secret claim, but they haven't taken steps to protect the so-called trade secrets, then they're going to have a hard time prosecuting that case. And other best practices are limit the scope and number of employees who have access to the trade secrets or the information. And if it's electronic information, it should be password protected, and steps of that nature should be taken to protect it from disclosure. In California, just as a side note, and I'll get to non-compete agreements in a minute, but there's a risk in California that a trade secret non-disclosure agreement could be stricken, even if it's independently enforceable in California, if it's included in an agreement that has an unlawful non-compete clause. So that's one stubborn area of California employment law, and I'll get to non-competes and why that is in a moment. Employee inventions. Jeff asked me to touch on this. You have kind of the issue of who owns an employee's invention. There's a basic distinction between employees hired to invent and employees not hired to invent. So the prototypical example I pulled out of the cases here, just because I thought it was quite illustrative, was where a chief engineer who was basically hired to invent and patent valves used in an oil company's manufacturing process. Those valves and those improvements to the valves that he invented were obviously his employer's. The second example of an employee not hired to invent was a mechanic who developed a twist lock system for a crane operator, and the reason he wasn't quote unquote hired to invent is that the development of that twist lock system essentially wasn't in his bailiwick or wasn't part of his job duties. Their employers sometimes, if you can put in a contract that and it may be enforced, that at least the employer would have a shop right is what it's called, to license an invention if there is one. And that can arise through express or implied agreements. And employers may also attempt to have employees assign the employer all inventions, but those agreements won't be upheld if the employee did not use the employer's equipment, supplies, facilities, or trade secrets, and if the invention was developed entirely on the employee's own time. And additionally, if the invention doesn't relate to the employer's business. Non-competition, non-solicitation. Generally, non-competitions are upheld outside of California if they're reasonably limited in time and geographic scope. In California, they are basically invalid as a general rule. There are some exceptions, but they are tough needles to thread. The first, I think most commonly cited one or attempted to be used exception is number one here, where the employer takes the position that the non-competition agreement is necessary to protect its trade secrets. The problem with that is it conflicts with the California rulings where courts have refused to implement the inevitable disclosure doctrine. So the situation there, one I've run into, is where an employer has a sales rep who has access to sensitive, customer lists and pricing material. They go across the street to a direct competitor and to fill essentially the same sales position. You have a strong argument that even if the sales rep didn't physically take the customer list across the street, he's inevitably going to put that knowledge to use for the competitor because, the customer list, for all intents and purposes, is in his head, and he's aware of the pricing strategy of the former employer. But even that is tough to implement in California, unfortunately. There are a couple other exceptions here. Covenants not to solicit coworkers might be upheld, even if no trade secrets are involved, but that would not extend to hiring unsolicited former coworkers. And covenants not to compete will be upheld where they deal with non-employees. So, if one businessman sells a business to another, you can implement a non-competition agreement to protect the goodwill of the business. Non-disparagement clauses, just one best practice, I think, where executives choose to leave is to perhaps structure the payments over time to give the executive more of an incentive not to say anything disparaging. And companies, I've found, are generally more willing to enforce a non-disparagement clause if it's coupled with an arbitration agreement. So the implication there is if executive leaves, they've signed a non-disparagement clause, they're violating it, but then you think through your options, and taking them to court and having that dirty laundry aired there may not be the best option. So our arbitration and a sound arbitration agreement is probably advisable in those situations to keep things private. Non-disparagement with lower level employees is a little more problematic, particularly in light of some recent NLRB rulings. And the upshot there is if you're going to limit employees' speech, and this arises with social media policies of employers, and in a recent DirecTV case where they had basically said you need the company's permission before you ever talk to the media, that those types of policies are going to be, they're not going to be upheld or held lawful because they need to have a carve-out to protect the employee's right to, seek to change or discuss with their coworkers the wages, hours, or terms of their employment. That's a protected right under the NLRA. And the same thing with social media policies, that you have to stay away from blanket policies, blanketly, say, prohibiting discussion of the employer. There are unprotected activities which can be prohibited, such as saying false things about the employer. But the protected activities are essentially complaining about the workplace regarding or discussing wages, hours, and working conditions. Wage and hour laws, I won't go on too much about this. It's quite boring, but unfortunately it is ripe for the picking for plaintiffs' lawyers, especially in California and New York, where I saw a statistic recently, and I think it was 78% of all dollars paid out in settlement of wage and hour claims were paid out in California. and New York. I think California accounted for about 50% of that. Wage and hour is, has a very boring definition. It's essentially, how work time is measured and how workers are paid for it. Wage and hour also includes the issue I've alluded to previously, salaried versus hourly employees. And the basic principle for non-salaried employees is that they should be paid for all time worked and time and a half for overtime, 40 hours in a work week federally, and there's a daily overtime requirement in California. The very boring, mundane things that can lead to class actions are listed here. Some of the ones I've seen are vague work week definitions or a shifting work week definition. It may seem very innocuous, but a poorly drafted definition of a work day or a work week in an employee handbook can have significant, if it's held to be illegal in that it wrongly denies employees of overtime, can have significant kind of multiplying effect depending on the size of the workforce. Remote work is a hot wage and hour class action issue, work from home or on a smartphone. And off-the-clock work is similar. That's more where somebody comes into work and, say, works for 10 or 15 minutes and then clocks in, or say they clock out and work for a few minutes afterward. In isolation, a single plaintiff case, these aren't going to be, the risk of liability is not that great, but the larger the workforce, the more troubling this stuff gets. And another thing is auto deductions for lunch periods. Employers should keep accurate records of lunch periods in California. This is a California issue mainly. But it's very problematic where the timekeeping system just automatically, takes an hour out of somebody's pay every day, because you don't have to pay for the meal period, because and there's no flexibility. There's no way for the employee to go to a manager and say, no, I actually didn't take my meal period, or I took it at a different time. There's a Penske case down here pending where it looks like Penske's run into some troubles with one of those types of auto deduct timekeeping policies. Leave laws. Leave laws can be a real headache, and I think basic requirement is to just make sure you have your bases covered in the employee handbook, and hopefully have good HR folks or someone at the company who can work through those issues of eligibility for leave, when leave is granted, the appropriate scope of, say, medical certification to get leave, and then California has its a couple of its own types of leave. It's got some additional pregnancy leave if there's a disability caused by the pregnancy, and we have a kin care statute, which essentially says if the employer gives employees sick time, the employer has to let the employees use that sick time for a sick spouse or child or partner. And it can be quite problematic if that policy isn't implemented, say, when an employer expands into California. Just a quick overview, I think, of some more, I call them traps for the unwary, or unique idiosyncratic aspects of California law that can be costly. There's as I mentioned before, there's a daily overtime requirement, so that's any time worked in excess of 8 in a day. The weekly and daily overtime, they're not compounded, or as the cases say, they're not pyramided. So, if at the end of the week somebody worked 42 hours, and those 2 hours obviously they're weekly overtime, but they count somewhere along the line as weekly overtime, you're not going to pay it twice. It's only 2. Arbitration clauses. this is a very easy best practice to implement out here, is having, if you have an arbitration clause in an employee handbook or employee agreement, it has to meet what we call them the Armendariz factors in California, just after the Armendariz is the case that held that any arbitration agreement with an employee has to have 5 elements, or it's not going to be upheld. One is a neutral arbitrator will be appointed. It allows for at least minimal discovery, as you would get in litigation. Third, that the arbitration will result in a written decision by the arbitrator, and that it can't cut off types of damages or relief. The arbitration agreement can't. And then lastly, here's the big one we usually see where that causes the arbitration agreements to be unenforceable, is that they must have the employer pay for the cost of the arbitration. You can't shift the costs of the arbitrator's fees or expenses to the employees. And then one other best practice with respect to arbitration clauses is to not have them buried. I would say this for at-will provisions too. Not have them buried in an employee handbook. They should be, separate, standalone aspects of an employee handbook that the employees should separately sign and acknowledge. It's generally not a best practice to just have an employee, sign one handbook acknowledgement at the end of the handbook saying, I've read and understand the above. These key provisions, at will, arbitration, should be separately acknowledged. Meal and rest periods is a big issue in California. Lots of class actions have been filed alleging meal and rest period violations. The upshot with meal periods is subject to some nuances that I won't bore any of you with. You get a meal period out here for about every 5th hour of work, and it should occur prior to the end of your 5th hour of work. 30 minutes unpaid, and then you would get a second meal period if you work a shift in excess of 10 hours. Rest periods are 10 minutes every 4 hours. The law actually says a major fraction thereof. Basically, 10 minutes for every 3.5 to 4 hours. 20 minutes for shifts of more than 6 hours, and so on. Record keeping and waiting time penalties. These unique California requirements have very disheartening to clients, sort of multiplying effect on the price of settlements, the cost of settlements, and the cost of the magnitude of potential liability. And what I mean by that is California has a very specific, for instance, itemized wage statement statute, which requires that on everyone's pay stubs, the employer's name and address be listed, the employee's name, last four digits of Social Security number, gross wages earned, hourly rate, etc. And what happens, and there's penalties of $100 and $200 for every infraction of the statute, and it fortunately is capped at $4,000. But what happens in a lawsuit, say, where an employee is held to have been misclassified as an exempt employee, say there's 100 employees that are ruled to be misclassified. This claim, the record keeping or itemized wage statement claim, is added onto that. It's sort of derivative. The logic being, well, if you weren't paying them as an hourly employee and keeping track of their overtime, then their pay stubs are inaccurate. So you violated that statute too. So you take $4,000 times 100 employees, and that might even eclipse actual damages in some cases. But it's a headache, and it's a point of leverage that plaintiffs' attorneys wield out here. Waiting time penalties is somewhat similar. The basic requirement on waiting time is if you fire an employee, you need to pay them immediately on their final day of employment, pay them all their all their wages accrued up to that date, and payout of any owed sick time or vacation time, if any. And if an employee voluntarily resigns without notice, then you have 72 hours in most situations to get them their final check. So the way and the fine or the penalty for that is up a day's wage for every day they weren't paid after their termination, up to 30 days. It's capped at 30. So this also becomes a costly derivative claim, say, for instance, in that in an unpaid overtime case, again, where if the plaintiffs end up proving, yeah, I wasn't paid overtime, I should have been paid overtime, and that in addition to the unpaid overtime, I'm entitled to 30 days of waiting time penalty because on my last day of employment with the employer, you hadn't paid me any of my paid overtime. So again, that becomes a pretty large multiplier of damages and potential liability. California also has a mandatory sexual harassment training requirement, ironically signed into law by Arnold Schwarzenegger, whom, as you may know, impregnated his domestic employee. It requires that supervisors be trained every 2 years. There's no per se, like penalty or anything for not providing the training, but it's one of the first things if an employer is ever investigated by the DFEH, which is kind of the local EEOC out here. They're going to ask for proof of training, and if you can't provide proof of training, then it's going to be a headache. And also plaintiffs, when they file a lawsuit, they frequently and increasingly try to point to the absence of evidence of training as evidence of discrimination in their situation. I've always thought it's a bit of a stretch, but it's an argument that's frequently raised. Credit checks, I think these laws have been passed in a few other states as well, but California recently passed limits on the extent to which employers can use credit checks in making new hire decisions. There are some exceptions, including for managerial positions or positions that involve regular access to bank or credit card information, or a position that involves access to confidential or proprietary information. The last one of these, like we have a couple minutes, briefly, with vacation policies in California, we see this all the time, that a client will have a well-intentioned handbook, but it'll say, you get 10 days of vacation a year, and you've got to use it by the end of the year or you lose it. That's unlawful in California. You can achieve the same result, you just have to phrase it differently. Instead of saying use it or lose it, what an employer can say is, you accrue 10 days per year, but if you don't use them, you stop accruing them. So it's a little odd, but you can achieve the same result. You want to avoid what California courts call forfeitures, and that's basically telling something they've lost something that they've accrued and earned. Expense reimbursements is kind of a unique area to California law. That's basically the employee is entitled to reimbursement for any expense they reasonably and necessarily incurred on the employer's behalf. The courts out here don't really care how you reimburse employees, just so long as you do. So stipends are fine as long as they're reasonably approximate expenses, and expense sort of receipt submission process whereby you submit receipts and the employee's paid that way. That's fine too. And the IRS mileage rate is presumptively valid out here. I think that's around 55 cents a mile if the expense at issue is an employee's mileage. And then just lastly, quickly, the commission. If you have a salesperson with a commission agreement, they must be in writing, including the terms of the commission agreement and the method for computing the commission. And one issue with commissions we see are chargebacks where somebody quits, and say there's a requirement that in order to get the commission, the customer must stick with the company for 2-3 months, and how does the employer recover that commission if the if the customer or the client bails before the end of that period? And those things need to be set out really clearly in the agreement. And if there is a chargeback to the employee, the salesperson's pay, it can't reduce their pay for that pay period below the minimum wage. So that's a biggie too. I think that's all I have, Jeff.
Thank you, Jeremy. So at this point, we'll have one or yep, still awake. You didn't quite put me to sleep yet. Before we get a couple, just one or two questions for our panelists, want to give you the code for New York, and it's a 4-digit code, H as in hotel, 5, 9, and then V as in Victor. So that's H, 5, 9, Victor. And if I think there's instructions on how to submit that on the attorney affirmation form. So with that, one question, Jeremy, and I guess part of this is can mandatory and binding arbitration be enforced? And I think generally in California, at least in just the commercial context, that's sort of a topic that it is a fairly hot topic out here, because for the most part, in most contexts, waiver of jury trials cannot be enforced, and so those provisions in contracts are invalid. And so the kind of primary attempt that drafters do to get out of that and effectively get a waiver of a jury trial is they require mandatory arbitration and binding arbitration. And in most corporate and contract contexts, those are fine. I think, Jeremy, you had pointed out in the employment kind of world, there is a case that requires 5 specific items to be met, or else those provisions in California at least are invalid. Are there other states that have similar? I know in a lot of these contexts, kind of California is the most onerous in many kind of respects. But is that sort
of I would I haven't encountered it specifically, but the way it's set up with the federal law, the FAA, and there was the recent AT&T case that reinforced this, a federal law that basically strengthened the enforceability of arbitration clauses. But it left to the states to strike the clauses if under its common law, the arbitration agreements were unenforceable or unconscionable. So the setup in California is, if an employer can prove that it was procedurally unconscionable and substantively unconscionable, they'll get it stricken. And I suspect most states have kind of a similar procedure. And the unique thing is, in California, at least for an employee, the arbitration clauses are always procedurally unconscionable, because it's take it or leave it or you don't get the job. But they also have to prove substantive unconscionability. So that's where you get those factors, the Armendariz factors. And if the arbitration clause has those factors, then it should be upheld by the court. There's still a few issues out here that are pending on appeal, such as whether you can waive class action rights and whether you can waive the right to bring a claim before the labor commissioner, but those things are pending.
Okay.
It's
So-
frustrating. I mean, I have clients who they bring the arbitration clause to me at the beginning of the case, and I say, sorry, we could try to get this enforced, but the judge probably is not going to do it because it's missing these factors. And they'll come back to me 3 months later, 6 months later, and be like, now, wait a minute, why aren't we in arbitration? And I'll have to remind them that they, unfortunately had a poorly drafted policy.
Yep. So with that, we're sort of out of time on this particular webinar. We do have a couple other questions that were submitted. We will respond to those questions. In addition, just kind of an offer to the participants that if any of you have, there's probably a couple areas, but if any of you have specific questions you'd like to bounce off us, just contact, shoot me, Jeff, or Zuleika, or one of the panelists, and the question, and we can kind of respond to that. I think part of our offer was we were going to give sort of a free couple of questions, to the participants, and also offer that if anyone wanted us to take a quick look at their handbook or kind of run through any particular fact scenarios that may be applicable to employees of theirs, those would also be, we'd also offer that assessment to participants. So with that, thank you, panelists. Thank you, Josh, Jeremy, and we hope to see you guys and the participants back at future webinars. Thanks.
Ladies and gentlemen, that does conclude today's conference. We thank you for your participation.